Desserud, Professor of Political Science, University of Prince Edward Island.
Don, there's an important court ruling coming out tomorrow in Quebec. Can you tell me about what that is?
Yeah, what's been going on since back in the previous Parliament, the federal government has been trying to find ways in which they could reform the Senate for reasons that most people are now well aware. But the federal government has been trying to find a way that would circumvent certain amending formulae that are in the Constitution. In other words, they're hoping that they can simply change address the problems of the Senate without having to go through the complicated procedures of constitutional amendment. But this has run them afoul of various provincial governments who have said, well, hold on, we have a stake in the Senate. The Senate is designed in a federation to represent regional interests and provincial interests, and we're not so happy with you going in and changing things without us being involved in the process. And they're pointing to the formula in the Constitution that says that if you're going to change the Senate, change the term of senators, the power of the Senate, method of selecting senators, there are certain procedures you should follow. So one of the governments that has taken issue with the federal government's tactic in this one has been the province of Quebec. And about a year and a half ago, I suppose, I was contacted by their Department of Intergovernmental Affairs and asked whether I would be willing to submit what they call an expert opinion on the issue of just what the amending formula are as they relate to the Senate and where was Quebec's position in this historically, going back to Confederation. I was one of several academics that were so contacted, and we had several meetings to sort of make sure that we knew what we were looking for, and then as a consequence of that I wrote the opinion, basically a research paper looking at the history of the amending formula, where they come from, and what has the provincial, and particularly Quebec's position been since Confederation on what their involvement would be.
So, and why did they come to you and the group of academics that they did? What
well,
did they
there are a number of academics out there, most of them political scientists, who have been interested in the constitutional aspects of Parliament. In political science, of course, we look at constitutions and we look at charters of rights and freedoms, but we also look at the way in which Parliament operates and the way in which the Constitution operates in a bigger context, and the relationship between House of Commons and the Senate and so forth. And that's something that I've been working on for a long, long time. It actually stems back to my doctoral dissertation, which I did on the origins of certain parliamentary conventions in the 18th century and the analysis of those that were going on through a French political philosopher named Montesquieu. But I've been sort of looking at that over time, and I pay close attention to Canadian politics as part of what I do as a political scientist. So I had published an article on Senate reform that came out in a book that the Queen's University Press published some time ago. I've also published articles on proroguing of Parliament, on the Confidence Convention. So they saw me as someone that had some background in this area and could look at how these sections of the Constitution do pertain to Senate and Senate reform.
So tell me about your submission. You were looking at the historical precedents then on changes to the Senate?
That's right. So in a nutshell, here's what's going on. In the Constitution Act of 1982, there are several different formulae that are used to determine what a constitutional amendment is going to be, and they have different ways of doing it. There's a general formula that says that 7 of the 10 provinces that constitute 50% of the population, plus the Parliament of Canada, have to be involved in doing certain things. There's a bilateral formula, there's a unilateral formula, and there's the unanimity clause. And the Constitution and the aspects of the Canadian governmental system, Parliament and so forth, are divided up according to these different sections. So you can amend some by using one, you can amend others by using the others. Where it becomes complicated and where the federal government thinks they have a pretty good argument is that there's one section that says that the provinces can unilaterally amend their own constitution without having to get the approval of any other province or the federal government. And provinces have used that section very rarely, by the way, but in all cases to abolish their own upper assemblies. So when provinces joined Confederation, they had an upper assembly and they got rid of them by using this amendment. So the federal government says, with that provision, it also says that the federal government can amend its own constitution unilaterally as well. They have said that this is the parallel. If the provinces can get rid of their upper assemblies or reform them without having to go through the complicated amending formula, we should be able to as well. So that's where that argument comes from. What I did is I said, well, that's not exactly what those formula mean, and that's not what they were intended to mean. And if you look back at the debates and the controversies that have gone on since Confederation, and by the way, trying to amend the Senate or change the way in which senators have been selected and so forth has been an ongoing debate since Confederation. This is not a new thing. And you look at all of the federal provincial conferences and the statements that provinces have made, because this comes up every once in a while, you see a very consistent pattern that they expected that they would always be, the provinces would always be involved in some way, and one of those formula involved anything that had to do with Senate reform. And I was able to show, or I tried to show, that the way in which these different formula evolved was designed in order to make sure that the provinces had some say. So what we're trying to do is figure out what was the meaning of the different sections of the Constitution now, what was the intention of those, and what was and how did they come to being into being. And what we were arguing from our side anyway was that the reason we have such a complicated set of formula is because they were trying to find an answer to all different contingencies, one of which was possibility someday of changing the Senate, maybe electing senators and so forth, but that was crucial to the provinces, and the provinces would be involved in that.
So the Constitution is difficult to change by design?
It is, and you want to do that because Constitution is supposed to be long-lasting, they're supposed to govern governments, and if the governments can simply change it without having to have any restrictions on that, then it's hardly a document that governs a government. If you can change it quickly, you can change it unilaterally, then it's simply ordinary legislation that has no real teeth. So all constitutions have some way in which they can be changed. You don't want them to be static and not be able to respond to the fact that the world changes. On the other hand, you don't want them to change too easily, so you have to have some way in between, and the way you do that is to have a formula that allows a various number of procedures to take place first before you can actually say that this is a constitutional amendment.
So we're expecting a ruling on that Quebec case on the 24th. What are the scenarios coming out of that?
Well, this is going to be very interesting, and I'm assuming that's going to happen. That the judges are going to say that the case before them, they have decided that either the federal government has the right to go ahead unilaterally without provincial involvement, or they don't, and then this is the format they should be using. What makes this tricky now is that the legislation that they're originally looking at was legislation that was put forward in the last parliament that has since been prorogued, in which case that legislation no longer exists. Now it can be reintroduced, and there's ways in which it can be reintroduced quickly, but right now it's in abeyance. So that's a little complicated. And the second complication is that and since then the federal government has gone forward with what we call a reference case. In other words, they've asked the Supreme Court directly to answer the same set of questions, in a sense circumventing the lower courts. It's a procedure that we have in Canada that allows the federal government to do that. So the Supreme Court, in other words, is now looking at the same case, and they have scheduled their hearings for sometime in November. So I'm not sure what the Quebec Court is going to do in the context of the fact that the legislation that they originally were looking at doesn't exist anymore. So it's just become a moot case, and courts are usually very nervous about, or not nervous, but they're not particularly happy with dealing with cases that are hypothetical. The Supreme Court, on the other hand, does, and then that's the proper venue for that. So we're going to sort of see how they nuance that. It wouldn't surprise me, however, that they would go ahead with a ruling one way or the other, because I'm suspecting that the Supreme Court would be welcoming that. The Supreme Court would like to hear what another court has had to say about the same issues so they can evaluate it in their own deliberations.
Very interesting. Don, thanks very much.
You're welcome.